Good morning, everybody. We ready to go?
Good morning, Your Honor. We are at the jail. Thank you.
Great. First matter is going to be an interpreter matter. Javier Salas Robles.
Yeah.
Sir, you have a warrant in the amount of $1,500,000.
The interpreter's on mute.
Oh, okay. Now, okay, I don't know what happened. I'm sorry. I'm on the phone. I'm ready. Sorry about that.
All right, sir, you have a warrant in the amount of $1,500,000.
Señor, usted tiene una orden de arresto en el total de $1,500,000.
You're free to post that bail at any time.
Usted puede pagar esa fianza en cualquier momento.
No. We'll see you March 6th at 9:30 for the filing of the fugitive complaint.
Nos veremos entonces el 6 de marzo a las 9:30 para hacer entonces el documento de fugitivo en ese entonces.
Stephen Flood, and then Jessica Clay.
I'm sorry, Your Honor. Is that it for the interpreter?
Yes, thank you.
Thank you.
Mr. Flood, and he's waived his personal appearance today.
All right, what does the state feels appropriate on these two matters?
Your Honor, the state's requesting $3,000 bail on each case with pretrial services supervision if he's able to post. He scores a 13 on the risk assessment. As far as recent criminal history, he's got a misdemeanor arrest for trespassing and destruction of property. He was found not competent in that case in July of 2025. He also has a trespassing and unlawful excrement case from 2025, which was no issued. He has a couple of convictions in 2024, though. He's got a misdemeanor conviction for trespassing, a battery, another battery, and it looks like a gross misdemeanor arrest for destruction of property that was no issued for further investigation. He's got additional criminal history spanning, looks like decades. It's 35 pages long, includes additional history from Texas and Pennsylvania. And so he's a high risk of continued criminal conduct. I would note that the neighbors in this case told officers that he continues to be a problem in the neighborhood. So the state is requesting bail in the amount of $3,000 on each case with pretrial services supervision.
All right, thank you, defense.
Thank you. We would ask that we would submit to that bail, but we would ask that it be interim. As the state highlighted, Mr. Flute does have a history of being deemed not competent. We have been unable to speak with him and unable to reasonably assess whether or not there are additional resources that we could bring to bear to identify safety measures in the community. Therefore, we'd ask that it be interim at this time, Your Honor, with no opposition to the amount.
All right, thank you. I will mark him as interim since he hasn't been able to assist you yet, but based on his risk score and our 10% rule, it'd only be $300 to get out on those two cases. So I'm setting the bail at $6,000 on each one. Bail is interim. Pretrial supervision of bail laws make all court appearances March 6th at 9:30 a.m. for the filing of the criminal complaint. Thank you. Clay and then Gilliams. Okay. All right. Miss Clay is here for burglary, uttering, scored an 8, was overridden or hired a reoffender, failed to appear. What's the state feels appropriate?
Your Honor, the state's requesting bail in the amount of $15,000, pretrial services supervision with testing for controlled substances if she's able to post. No contact with Ellen Faulkner and the Great Basin Bank branches. She's got a gross misdemeanor conviction in 2025 for battery on a protected person. Looks like she's got 180 days suspended on that case. She was remanded at her arraignment in district court due to positive tests and multiple pretrial violations. Other than that, her only other criminal history is back in 1997, misdemeanor convictions for battery and disturbing the peace. However, it looks like the likelihood of conviction in this case is very high. She, as I mentioned, she had some issues pretrial supervision last year on her other case, and she was just very recently convicted on that gross misdemeanor offense. So the state is requesting $15,000 bail, pretrial services supervision with testing for controlled substances, no contact with Ellen Faulkner and Great Basin Bank.
All right, thank you, defense.
Thank you, Your Honor. Your Honor, we would agree to all the conditions but the monetary bail. I don't believe the state can show that clearly and convincingly the monetary bail is required. Miss Clay scores an 8, and I believe 3 of those points are for residency and cell phone number that had not been verified. We were able to contact Simona, who is Miss Clay's sister. She verified residence, employment, and phone. I believe that there are less restrictive means than monetary bail, which is disfavored according to Valdez Jimenez, unless the court can show that it's the only thing required. Given that there is that one recent case, I think it's appropriate to have additional supervision measures in place. But with that medium risk, which I think this court has said is 92% chance of appearing and not committing a new crime while on bail, I believe that it's appropriate for the court to have those supervision measures in place, but set an OR release in this matter. This is nonviolence. There's no history of nonviolence, and there's no history of failure to appear. In fact, while I understand the state's point about coming with a positive test, the fact is she did come and tested positive, and that's what we want to see. I think when someone is struggling with behavioral health issues, that they're still making it to their court appearances, and Ms. Clay has demonstrated that. Therefore, I think that it can be viewed both ways, and I would ask this court to OR with those conditions.
So I happen to have the validation study here of the NPRA, and low-risk individuals, there's a 96% chance they'll remain crime-free, 87% chance they'll make all court appearances. Medium-risk individuals, 80% chance they make all court appearances, 84% chance that they remain crime-free, 69% chance composite, that meaning that they do both that they're required to do, remain crime-free and don't fail to appear. The issue is the override in this case, and even with the defense's verifications, and I've said it before, I'll say it again. It was in those meetings with Dr. Austin, and he looked at when pretrial services overrode individuals, and he found that they correctly did so, meaning if they overrode them to hire to reoffend, they behaved as a hire to reoffend. And the composite score for those folks is 59%. That means 59% of the time do they make all court appearances and remain crime-free. So, difficult situation in Miss Clay's case. She has that district court case, and what would you tell me again, Ms. Phelps? I know she had a violation. What is the status of that district court case, though?
So, Your Honor, the status of that case, I didn't write down the sentencing date. I can pull that up right now. But it's my understanding
she's pending sentence.
No, she's been sentenced. She was sentenced to 180 days suspended with conditions.
How does she get 180 days in district court?
On a gross misdemeanor.
Yes, Your Honor, it's a gross misdemeanor, and so I guess they decided 364. They split that in half and did 180.
Okay, interesting. All right. Well, that's the I think the linchpin here is you're on a sentence, a suspended sentence at the time you commit the offense. I think that certainly with the NPRA and the override shows the defendant a state shown by clear and convincing evidence that bail is necessary to ensure the safety of the community. The appearance of the defendant be set as requested, $15,000, no contact as ordered or requested, I should say, random drug testing, pretrial services supervision, no bail laws, make all court appearances March 6th and 9:30 is the defendant's next court date. We'll see you back then. Good luck to you. Gilliams. And then after Gilliams is Satz.
Your Honor, I believe Mr. Gilliams waived appearance.
All right. PCS paraphernalia and also an open warrant case. Scores a 9. Was the statement appropriate?
The state's requesting bail in the amount of $3,000 pretrial services supervision with testing for controlled substances. So this is a low amount of methamphetamine. However, he was booked also on a failure to pay or failure to comply warrant. He's got criminal history out of 5 states. Most recently, he's got a misdemeanor conviction for possession of drug paraphernalia with a failure to appear warrant, which he admitted to that. And then he's got additional, looks like misdemeanors, some gross misdemeanors, also some felonies going back a couple of decades. He's got a 2022 misdemeanor conviction for trespassing with 2 failure to appear warrants. He's got felony convictions for unauthorized absence by a prisoner in 2009, attempted burglary in 2007, attempted grand larceny in 2002, PCS also in 2002, and an uttering in 1999. As I mentioned, he's got lots of additional misdemeanor convictions, mostly for controlled substances related offenses. So the state is requesting bail in the amount of $3,000 due to his risk of both continued criminal conduct and future non-appearance, pretrial services supervision with testing if he's able to post.
I think you defense.
Thank you, Your Honor. Your Honor, the thing that I would point out is I believe that, again, we have a 9 here, and there are homelessness struggles and struggles with addiction. That's clearly established by the history. But I believe that his off-paper date on the last possession of drug paraphernalia was mid-June 2020. He's remained in the community since then. The pretrial services was able to confirm that. That suggests that he has some amenability to treatment and oversight. In this case, the stop was for a relatively minor offense. It was a bicyclist without a front light or rear reflector. Given that, and then that the detention was for the Reno Municipal and the very minimal level, it was a search incident to arrest found 0.92 gross grams that included the bag. Given the totality of the case, I don't think the state has shown by clear and convincing evidence that monetary bail is appropriate. Daily check-ins are not an option anymore, but testing is. Testing would be the way to keep to connect to the nexus of events, but acknowledge the relatively minor criminal history.
I'll give you a shot. So owner cognizance, random drug testing, daily mutual support group meetings until in treatment, pretrial services supervision, obey laws, make all court appearances. March 6th at 9:30 here at the Reno Justice Court. It's the next court date.
Thank you.
You're welcome. Sats and then Pinedo Escalante.
Court's intelligence 1. Mr. Sats said no, he will retain. He did ask for a public defender to be appointed, and he waived his appearance.
What's the state's appearance? Sorry, what is the state's? Hold on, I'm looking at the PD part. All right, he was appointed. You're right. What's state's position?
So, Your Honor, I'm not sure if the criminal complaint has filed in this case yet. I know it looks like we submitted it.
It was filed.
We're filing, as Your Honor can see, on misdemeanor offenses, assault and battery. We were able to get in touch with the named victim in this case. He indicates he does want a no contact order. He says he is afraid of the defendant, who's a stranger to him. As far as criminal history, Mr. Sats scores a 13 on the risk assessment, has 2 points for failures to appear. He has 14 Reno Municipal Court cases between 2018 and 2024, with 7 failure to appear warrants. Most recently, it looks like he's got 4 misdemeanor convictions for possession of drug paraphernalia in 2025. 2024, he's got a trespassing citation. He failed to appear at arraignment in that case. Looks like a garden variety of misdemeanor convictions going back to 2017 with a couple of violent convictions in there. He's got a couple of convictions for assault in 2020. In that case, his supervised bail was revoked and a failure to comply warrant issued after he failed to check in with pretrial services supervision. It looks like he also had a felony arrest in 2023 for battery with a deadly weapon, but we no issued that case. So it looks like he's got lots of compliance issues within the last couple of years, as I mentioned, numerous failure to appear warrants. This is a crime of violence, regardless of the fact that the state chose to file misdemeanors and not the felony offense. So the state is requesting bail in the amount of $10,000, pretrial services supervision, and no contact. I'd request it looks like there's 2 victims, Mr. Sean McNeil and Sean Wood.
All right, thank you, defense.
Your Honor, based on Valdez Jimenez and the information, we were not able to confirm additional information, and he does score a 13. Well, I recognize that this is a misdemeanor case, and so bail should be set low. I also recognize the state's arguments. I would submit to the court.
All right, state shown by clear and convincing evidence of bail, even outside the defendant's ability to make it is necessary to ensure the safety of the community and the appearance of the defendant. Said was requested $10,000, no contact. Separate criminal offense pursuant to NRS 1784845 to a maximum 120 days. Pretrial services supervision of bail laws make all court appearances. March 6th at 9:30 a.m. is the defendant's next court date. We'll see you back then. Pinedo Escalante and then Jones. It's the fugitive warrant for Mr. Pinedo Escalante. We'll see you back. It's a California warrant. We'll see you back next week for the filing of the fugitive complaint. That is March 6th at 9:30 a.m. Jones and then Yazan Abarak.
And Your Honor, the last name on the gentleman at bat, I should have said it differently. I'm so sorry, is Barrick, the pronunciation.
All right.
Thank you.
Jones and then Barrick. Jones has a few things going on. One is listed as a bail hearing and arraignment. So does he have a copy of the criminal complaint?
We don't, Your Honor.
All right.
Generally speaking, we don't do arraignments on the weekend. We're happy to when it's no jail, but some of the dialogue about speedy prelims we don't usually do. I can do it quickly if the court would like to trail this to the end. I'm happy to do it. We're moving fast.
That's okay. We'll do it Monday. That's fine. But let's do the bail then on these two cases where the state feels appropriate.
So, Your Honor, the state's requesting $50,000 bail on the warrant case. That's the RCR 2025-133018, $100,000 on the new fentanyl trafficking case, pretrial services supervision with testing for controlled substances, and no firearms if he is able to post. So he's got the two cases. The one was the warrant case. It looks like the offense dates are both in July of 2025. Those were controlled buys. The likelihood of conviction on those is apparently going to be pretty high. He scores, let's see, the newer case he just picked up yesterday. He possessed, looks like, quite a bit of fentanyl, over 60 grams of fentanyl, over 76 grams of meth. Actually, it looks like over 70 grams of fentanyl with the smaller packaging. And then the police also booked him on possession of a stolen firearm, felon in possession of a firearm, and it looks like he scores a 9 on the risk assessment. He's got 3 pending traffic matters. He was also booked on 3 failure to appear warrants, but he was scored 0 points for failures to appear. I'm not sure whether that's because those are traffic matters or what the issue is with that. The bail was initially set at $15,000 on the warrant case, but based on the continued criminal conduct, the risk to the community, the failures to appear, I do think that an increase is appropriate on that case. As far as prior criminal history, he's got a misdemeanor conviction out of California in 2021 for hit and run. And then back in 2011, he's got felony convictions out of California for first-degree robbery with a firearm, second-degree robbery with a firearm. He was sentenced to 12 years in prison on that case. So that would explain the lapse of criminal history between 2011 and 2021. So as I mentioned, very high risk to the community, risk of future non-appearance. The state's requesting $50,000 bail on the warrant case, $100,000 bail on the new case, pretrial services supervision with testing for controlled substances, and no firearms.
Mr. Jones, you said you're going to hire your own attorney. Is that still the case?
Yeah, if I can, yeah.
Well, I don't know if you can you?
Yeah, I could, yeah.
You can hire your own attorney?
Yeah, I just gotta call I gotta call my girl.
Okay, so you have a choice this morning. The statute says I can appoint counsel if you're indigent. That means you don't have the money to hire an attorney. You can represent yourself today on these bail hearings. You can ask for a continuance in order to retain counsel, or you can apply for the public defender. Those are your 3 options. Pick one.
Court's indulgence, 1 moment.
Judges that appoint to the bail hearing.
Your Honor, if you could please canvass Mr. Jones as to present income, that his desire would be to have the Washoe County Public Defender's Office appointed.
All right, sir, raise your right hand. Raise your right. Do you solemnly swear under penalty of perjury that the evidence and testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Yeah, all right. Tell me about this money you were going to use to hire an attorney.
I don't have any money, but I was gonna see if like my family can come together.
So you don't have any money?
I don't have any cash, but I was gonna see if my family can come together and do something for me.
So how do you get by if you don't have any money?
I'm an arborist. I'm a seafarer. When I was in prison, I went to fire camp, and so they trained me to be a seafarer. So I can pick up like work like that. I got like paperwork to show like I'm a seafarer. I'm a directional seafarer.
So you have no job?
Your Honor, it's my understanding in speaking with Mr. Jones's girlfriend that we have confirmed he works intermittently. There's no regular employment, but that he is a certified arborist who seeks out jobs intermittently where possible. But there is no salary that he could provide that is reasonably reliable to the court for the purpose of canvassing.
All right, appoint the public defender in each of these cases. Go ahead with your argument.
Thank you, Your Honor. Your Honor, I respect what the state said about the NPRA being a 9, but not reflecting those failures to, I believe it was a comply, though Ms. Phelps might be right, appear on the Reno Municipal. However, those do appear to be traffic tickets, usually resolved with a credit time served where there's a violation. I'm not sure what the Reno Municipal standard is here. Aside from that, we were able to speak, as I indicated, to Victoria. The client, Mr. Jones, lives at a Park Street address that we were able to confirm. The address was not confirmed, so that would decrease his points, I believe, by the 2 that were not reflected for the failure to appear if this court finds those to be failures to appear. So he would remain at that medium risk or just high risk. But we were also able to confirm his cell phone number through girlfriend Victoria as well, which would put him at the medium risk in this case. He's been living in the area for a couple of years. As I indicated, he does have connections with his girlfriend here. He is trying to get a consistent job as an arborist with local landscaping businesses, but right now does it piecemeal. He is certified through his time in the California Department of Corrections. Based on the totality of the circumstances, we would ask that the bail, we believe that the state has shown the monetary bail is necessary. We would ask that it remain as set at the $1,500. That is a significant amount for someone that is not working and is indigent and qualifies for our services, but it is not a bail de facto outside the defendant's ability to make. And I don't believe that the court or state can establish the need to set it outside the ability to make. Therefore, that's what we would request.
All right, thank you. I believe the state has shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant will be set as requested in each case with the conditions as requested. His next court date is March 6th at 9:30 a.m. We'll see you back then, sir. Barrick. And after Barrick is Daly. Mr. Barrick, you said you were going to hire your own attorney. That's still the case?
No,
Why?
because I spoke with the public defender and I'm happy to move forward with her.
Doesn't work that way. If you got the money to hire an attorney, you have to hire an attorney.
I don't have the money to hire the attorney as well.
Then why'd you say you were gonna hire your own attorney?
That's just, I actually didn't say that. I was telling them, I'm not sure. I wasn't sure at the question when I was.
All right, raise your right hand. You solemnly swear or affirm under penalty of perjury, the evidence and testimony you're about to give would be the truth, the whole truth, and nothing but the truth?
Yes.
All right, what do you do for a living?
I was a senior treasury analyst working from home, and I recently started my own company in June of 2025, selling digital products and services powered by AI.
All right, so what's your income?
For last year, the income was like around 80,000 or so.
What are your savings and money you have available to hire an attorney?
I have none right now, sir. I just have my mother's help, who's here with me. She's in Reno here with me.
If you have the ability to reimburse the public defender's office, you'll be required to do so. I'll appoint you the public defender. What is the state feels appropriate on this matter?
Your Honor, the state's not objecting to an owner cognizance release for Mr. Barrick with pretrial services supervision with testing for controlled substances. He doesn't have a whole lot in the way of criminal history. He does have a citation for possession of drug paraphernalia in 2025 out of Reno Municipal Court, and he did fail to appear for his arraignment in that case. And then back in 2008, he's got a misdemeanor conviction for theft. So due to his lack of substantial criminal history, I do recognize he's got the 2025 case. I figure we can give him a shot. So I'm not objecting to the unrecognizance release, pretrial services supervision with testing for controlled substances.
Sir, I'm not going to give you the public defender. I'm going to have you try to hire an attorney first. This also could end up in a no jail misdemeanor complaint where you wouldn't be entitled to the services of the public defender. So I'm going to release you on your own recognizance, give you pretrial services supervision and drug testing. March 6th at 9:30 a.m. So try and hire an attorney. If you're unable to, then more than welcome to come in and apply. But we hear consistently that the public defender's office is overworked and under-resourced. And so I can't just be handing out their services if you have the ability to hire an attorney, which is what you originally said. So we'll see you next week. Thank you. Daly and then Furman.
Thank you, Your Honor. Mr. Daly did waive his appearance. We're prepared to proceed in his absence.
All right, what does the state feel is appropriate on this PCS, their defense, violation of release, scores in 11, warrants, and so forth?
Thank you, Your Honor. The state's requesting bail in the amount of $30,000, pretrial services supervision with testing if he's able to post that. Scores an 11, 0 points for failure to appear, but he was also booked on a failure to appear warrant. He's also got a district court hold, unsuccessful pretrial supervision in 2025. That pending case is an embezzlement and PCS 3+ case. In that case, he posted on $20,000 bail. He absconded from pretrial services supervision, failed to appear at his May 19th, 2025 OSC. He's got additional criminal history going back to 2010, including a felony conviction for resisting an officer with a deadly weapon, not a firearm, in 2022. He was sent to prison in that case. Looks like he's got additional felony convictions, some misdemeanors throughout. But the long and short of it is he's clearly a high risk of continued criminal conduct, a very high risk of future non-appearance. So the state's requesting $30,000 bail, pretrial services supervision with testing if he's able to post.
Thank you, defense.
Thank you, Your Honor. Your Honor, I believe that there is a basis for this court to impose monetary bail. However, we would ask that it be at the $5,000 on this case. Certainly, the other case can be considered on whether monetary bail should be applied, but I don't know that that raises the need for the monetary bail amount in this case. There is that other hold. He is appearing in Judge Freeman's court. It does need to be set, but on this case, it was, it appeared to be a rather minimal stop outside of a Mavericks with a very low, fairly low amount of a controlled substance when looking at the gross gram weight. Therefore, for this case, the pretrial risk assessments indicated no successful reference. We were able to speak with his sister, Sierra Daly, who confirmed telephone number, address, and she believes that he has an alternate way of making an employment through piecemeal work at a friend's company. I can't confirm that, obviously, but that does give cell phone number, residence, and confirmed reference. Therefore, given the totality, we would ask that the bail be set at $5,000.
This 17847 says that if the proof is evident, the presumption great, defendants committed a felony while out on release may be held without bail while the state seeks to revoke the bail. on the old case. So the legislature clearly is very concerned about individuals like this, especially when they posted $20,000 bail, and that was insufficient. So I think the state has shown by clear and convincing evidence, bail outside the defendant's ability to make it is necessary to ensure the safety of the community and appearance of the defendant. We set at $50,000 in this case, random drug testing, pretrial services supervision, will bail laws make all court appearances March 6th at 9:30 a.m. is the defendant's next court date. See you back then. Furman and then Inglis. All right, we have this case with the DUI and then the weapons charge, and then we have an ADW in Sparks that bail is $20,000 on right now, and the public defender was denied. He said he was going to hire his own attorney. So the same thing in this case. So, Mr. Furman, 3 choices. Continue the matter so you can bring your private counsel here, represent yourself in this bail hearing, or request the services of the public defender if you can prove to me that you're indigent.
Continue with my own counsel.
Okay. You want to try and have him here tomorrow or Monday?
Monday, or no, tomorrow.
Okay.
Court's indulgence, just one moment. Tomorrow's
Monday, sir.
All right. See you Monday. Thank you. Inglis and then Yeager. PCS scores a 7, overridden to a higher to reoffender, failed to appear. What's the state feels appropriate?
Thank you, Your Honor. The state's requesting bail in the amount of $3,000 pretrial services supervision with testing if she's able to post. So as Your Honor mentioned, she scores a 7 on the risk assessment. Most recently, she's got a misdemeanor conviction for possession of drug paraphernalia in 2025. In that case, the state sought revocation of her own recognizance release in October of 2025. Her own recognizance release, I believe, was reinstated, and then in November she absconded from DAS, and then the case resolved in December 2023. She's got a misdemeanor conviction for DUI. She had 1 post-sentence bench warrant in that case. She's got 2 convictions for possession of drug paraphernalia in 2021. It looks like she was a CAP court graduate. She graduated, it looks like, in 2022. She's got a traffic offense in 2020 with a failure to appear, and then she's got 3 separate possession of drug paraphernalia mistos out of this court, actually, correction, 4, and a petty larceny convictions between 2017 and 2019. So she's both a high risk of continued criminal conduct and a high risk of non-compliance on pretrial. So the state is requesting $3,000 bail, pretrial services supervision with testing if she's able to post.
Here's the defendant does well when in treatment. Says she's interested in treatment, so I'll release her on her own recognizance, random drug testing, daily mutual support group meetings until in treatment, pretrial services supervision, obey laws, make all court appearances, March 6th at 9:30 a.m. to the defendant's next court.
Thank you. Court's indulgence, one moment, please. Sorry, Your Honor. Thank you so much, Your Honor.
Yeager and then Barahona.
Thank you, Your Honor. And Mr. Yeager waived appearance. I'm prepared to proceed.
Another PCS, but with a bunch of warrants, scores of 14. What's the state feels appropriate?
Your Honor, the state's requesting bail in the amount of $5,000 from Mr. Yeager, pretrial services supervision with testing if he's able to post that, scores of 14, also arrested on 2 failure to appear warrants and 1 failure to pay or failure to comply warrant. As far as recent criminal history, he's got a citation for trespassing in 2025 with a failure to appear warrant, a conviction for trespassing with a pretrial failure to appear warrant, and a post-sentencing failure to appear warrant. misdemeanor convictions for trespassing and possession of drug paraphernalia also in 2025, with a pretrial failure to appear warrant and a post-sentencing failure to appear warrant. He's got 10 cases out of Reno Muni between 2021 and 2024 with 10 failure to appear warrants, lots of misdemeanor convictions going back to 2001 out of several states. And he's also got a felony conviction for uttering back in 2006. So very, very high risk of future non-appearance and continued criminal conduct. The state's requesting $5,000 bail, pretrial services supervision with testing for controlled substances if he's able to post.
All right, thank you, defense.
Thank you. This is one, Your Honor, where we are warehousing addiction. I don't have a better alternative because I see that he scores a 14. I see that the amount in this was alleged to be 14 gross gram weight, so, or excuse me, 12 gross gram weight. So it's not just the dust. I don't know that this is the appropriate response to a mental health / behavioral health issue, but I don't have a better one. And I believe the state has proven it, but I still submit that this is not the appropriate response to addiction.
State shown by clear and convincing evidence that bail is necessary to ensure the safety of the community. Appearance of the defendant will be set at $6,000. Random drug testing, pretrial service supervision, no bail laws, mental court appearances, March 6th at 9:30 a.m. The defendant's next court date was seen back then. Barahona and then Fletcher. This is another PCS. Also has a credit card fraud case or charge, I should say. Scores of 12. Will the state be appropriate?
Your Honor, the state's requesting bail in the amount of $5,000, pretrial services supervision with testing if Mr. Barahona is able to post. Scores a 12 with 2 points for failures to appear. 2026, he's got a misdemeanor conviction earlier this year for possession of drug paraphernalia. Looks like he was released on his own recognizance in that case, and then he failed to appear for his arraignment. 2025, a misdemeanor conviction for possession of drug paraphernalia with a pretrial failure to appear. 2024, misdemeanor conviction for trespassing with a pretrial FTA. Misdemeanor conviction for possession of drug paraphernalia in 2024, much of the same between 2023 going back to 2012. Looks like most of these arrests are failures to appear, possession of drug paraphernalia. Then he's also got a misdemeanor conviction for domestic battery back in 2019. So very high risk of future non-appearance, continued criminal conduct. The state's requesting $5,000 bail, pretrial services supervision with testing if he's able to post.
Meyer.
Thank you, Your Honor. Your Honor, we have spoken with Mr. Barahone's mother, Ioli. She is not going to let him come back, but she is going to continue to hope that her son finds sober support in the community and hopes that he would be allowed to do an IAP to Reno Behavioral Health. That would be our request. In the alternative, we would also ask that this court consider releasing him prior to admission into the behavioral health. The intake program, as this court knows, can be complicated with the daily testing. Clearly, there's an addiction issue in this case. However, he does have significant ties to the community. He wants to do better and needs to get that support. His mom says that he has been trying, but he needs support to obtain. Court's indulgence, one moment, please. And Mr. Barahone just wanted to emphasize he's willing to test every day and do those peer support groups daily, even twice a day if the court orders.
I appreciate that, sir. Given your, if this was just a drug case and there wasn't the credit card issue, I would take a chance on you because the risk doesn't impose a burden on the community as far as victims, but it's a different situation when you're making your problem somebody else's problem, so to speak. The state shown by clear convincing evidence that bail is necessary to ensure the safety of the community. Appearance of the defendant will be set at $6,000. Random drug testing, pretrial services supervision. I will allow your release on your own recognizance with IAP to treatment as supported by an evaluation. Your next court date is March 6th at 9:30 a.m. We'll see you back then.
No, you can get released.
Fletcher and then Spooner.
Thank you, Your Honor. Both clients have waived their appearance.
All right, well, the state feels appropriate on Fletcher.
Okay, Your Honor. So for Mr. Fletcher, it looks like he's kind of got a lot going on here. We've got 3 different cases set this morning. One is a post-sentencing warrant arraignment. It looks like one is an arraignment or a bail hearing on an original arrest warrant and then a new obstructing. So as far as the harassment, that involves the same victim as several of his recent cases. He scores a 14 on the risk assessment, 1 point for failures to appear. It looks like he's got a 2024 misdemeanor conviction for domestic battery. I think that's the case for which he's set for a warrant arraignment this morning. That case involved the same victim. He failed to appear for his October 14th, 2025 OSC. He was ordered to have no contact with the victim as a condition of his suspended sentence. And when he was arrested on the obstructing case, he was with the victim. He's also got a misdemeanor conviction in 2024 for harassment with the same victim. 2022, he's got a felony arrest for domestic battery third and harassment. Once again, same victim. That case was dismissed due to inability to locate the victim. 2021 felony conviction for PCS. Looks like his OR was revoked in that case. A failure to comply warrant issued. He failed to appear after a revocation warrant issued. He was OR'd again by stipulation of the parties, then arrested by DAS a couple weeks later. OR'd again over the state's objection this time, and then arrested again within a month. 2020, he's got, let's see, a felony arrest for PCS and domestic battery third. He pled guilty to a fictitious domestic battery first. He had 1 post-sentencing failure to comply warrant in that case, 3 post-sentencing DAS arrests, 1 post-sentencing failure to appear. He had 1 additional, there was a request for a failure to comply warrant, which was denied after the court determined that it lost jurisdiction after all of those post-sentencing issues. He's got additional domestics going back to 1998. 2015, he's got a felony arrest for domestic battery strangulation, domestic battery third, another felony arrest for domestic battery third, a felony conviction for domestic battery third, and a misdemeanor conviction for stalking. Let's see, felony arrest for domestic battery third in 2013 that was dismissed. Misdemeanor conviction for domestic battery first in 2011, and then he's got some additional felony convictions. PCS with intent to sell in 2007, sales of a controlled substance and trafficking in 2006, sales of a controlled substance in 2000. And then he's got the 1998 misdemeanor conviction for domestic battery. We were able to get in touch with the named victim on the harassment case, Your Honor. She says she doesn't want a no contact order and she's back together with the defendant. However, as I mentioned, he was ordered to have no contact with her as a condition of his sentence in the 2024 128969 case. At the time of sentencing in that case, she was upset about the result because she wanted the defendant to go to prison. She's been a victim of his numerous times, and so the state believes that the no contact order is certainly appropriate and necessary to ensure her safety. The state's requesting that the court maintain the bail set on the harassment case at $20,000, pretrial services supervision, no contact with the victim, Danielle Hauer. And then on the obstructing case, the state would request $10,000 with pretrial services supervision. And then as to the RCR 2024-128969 case, the state would request that the bail remain as set on the warrant at $3,000. And I would request that the court set an OSC in that case.
All right, thank you, defense.
Your Honor, I would submit us to everything with the exception of the no contact order. If she's not requesting it, it does feel, given my old life with the National Council of Juvenile and Family Court Judges, there is a way that those who are victims, if that is how this court chooses to see her, moderate their risk and moderate their needs within relationships that have a history of violence. I believe allowing them the authority and autonomy to make that control is a way that the court can practice safety, especially given that whatever bail amount this court is going to set is likely outside his ability to make. I would ask this court to consider not imposing that condition. Absent that, I would submit on the rest based on the representations of the state and the NPRA.
All right, thank you. The state shown by clear and convincing evidence that bail is necessary to ensure the safety of the community and the appearance of the defendant. In RCR 2024-128969, there will be no bail. Order shall cause March 3rd, 8:30 a.m. In RCR 2026-134081, $50,000 bail, no contact with the victim, separate criminal offense pursuant to NRS 1784845 for the maximum 120 days. Pretrial service supervision, no bail laws, make all court appearances March 2nd at 9:30 a.m. for an arraignment. In the new case, false statement, $10,000 bail, pretrial services supervision, next court date March 6th at 9:30 a.m. I'll appoint him the public defender in that new case because he already has the public defender on the other cases. And unfortunately, in cases like this, the literature is voluminous with regards to victims not being in a good mental state to make the best decision about what is best for their safety. And so we're more than happy to do hearings in person so that we can get to the bottom of whether it is appropriate to allow contact. But at this point, there is ample evidence in this record that they need to be separated for her safety. Spooner is the last matter. And I think defense said he waived, so what does state feels appropriate?
Thank you, Your Honor. The state's requesting bail in the amount of $10,000 pretrial services supervision if he's able to post. Scores an 11 on the risk assessment. I don't have the breakdown of that. Looks like that was routed to Reno Municipal Court. He was also in custody on a draw deadly weapon and possession of drug paraphernalia out of Reno Muni. He's got a felony conviction for domestic battery by strangulation in 2024. He was sent to prison 12 to 30 months in that case. 2023 is his underlying sex offense. It looks like a gross misdemeanor conviction for indecent exposure. He's also got an obstructing conviction in 2023. He's got a gross misdemeanor conviction for conspiracy to communicate a bomb threat in 2022. In that case, he was removed from mental health court and his probation was revoked. 2016, a misdemeanor conviction for domestic battery second. Felony conviction for dissuading. Looks like his probation was revoked in that case as well. And then a misdemeanor conviction for domestic battery in 2015. So he's a high risk of continued criminal conduct. He was just convicted of a felony in 2024. He's got that underlying sex offense in 2023. So the state's requesting bail in the amount of $10,000 with pretrial services supervision if he's able to post.
All right, thank you. Defense?
Thank you, Your Honor. Your Honor, as the state has mentioned, there are some mental health concerns. When I met with him today, he was in Reds. There was some difficulty in communicating. I'm not quite sure whether it's substance abuse related or whether it's mental health, but I struggled with getting any additional information. I would submit, but ask it to be interim based on those communication issues.
$10,000 bail's interim, pretrial service supervision of bail laws. Michael court appearance is March 6th at 9:30 a.m. The defense next court date. Anybody else up at the gym?
No, Your Honor. I mean, the deputies and I, Jen Rains. But
All right. Well, anybody that needs to be seen. All right. Thank you so much. Have a great rest of your Saturday.
Thanks,
Have a
Judge.